Okay, so we are officially being recorded, and we will send out the recording link later so you can have that for yourself or to share it with other staff members. Again, welcome to our July Facts and Snacks. We're doing a 2021 legislative session summary, and thank you all for being here. A couple logistics. So in addition to recording, you all can type questions or comments or anything into the chat box. Please select all panelists and attendees if you'd like everybody to see your response. Otherwise, it will just go to the three of us. We'll see that. We will be sharing out the chat comments as we go through the presentation today. So we'll keep an eye on the chat box and try to answer questions as we go along. And I'm going to go ahead and throw it over to Amelia. Amelia Lobo is our public policy specialist here at Violence Free Colorado, and Jennifer Isle is the executive director at Project Safeguard, and they're going to give us some amazing information today. So thank you, Amelia and Jennifer.
Thanks, Brandy. As Brandy said, I'm Amelia Lobo, public policy specialist here at Violence Free Colorado. I just started at Violence Free in March, so new to the organization, but prior to that worked as a legislative aide and also before that as a domestic violence advocate. So I'm excited to be here now and to get to know and work with all of you going forward. And Jen, do you want to introduce yourself as well?
Sure. Hi, I'm Jennifer Isle. I'm the executive director at Project Safeguard, and I am really just here today to talk a little bit about the civil protection order component of House Bill 1255. And thanks to Violence Free Colorado for inviting me.
So today, we're going to be just doing a summary of the 2021 legislative session, which just wrapped up last month, going over just kind of a big picture overview of some of the primary bills that Violence Free Colorado worked on. We did in some way engage on about 40 bills in this last session, whether that was testifying on them, supporting, opposing, but there were 4 primary ones that we were really focusing our attention on throughout the session, and we're going to go into some detail on those and what you should know as advocates, what that changes, and some tips for those as we implement them. The session wrapped up on June 8th, which if you normally follow the legislature, you know is not typical. Both the 2021 session and the 2020 session were really heavily impacted by the pandemic. And so the place where we were coming into the session this year there was a lot of uncertainty around funding, a lot of bills that had been introduced in 2020 and then because of the pandemic didn't make it through, including our firearms bill, which was reintroduced this year and we're going to talk about. So in 2020, the legislature was going as normal until about mid-March, when of course things changed for all of us and the legislature suspended. And then when they came back a while later, they did so just for a few weeks and really focused on just some really urgent things to address the pandemic. And so a lot of other bills, especially bills that cost money, were just postponed indefinitely and didn't make it through. One of the other pieces at the end of the session last year was there were projections for the state budget, that the prediction is that the state would lose a lot of money. And so at the end of the 2020 session, the legislature cut about $3 billion from the state budget. So we came into this year not knowing, like, are we going to be able to pass bills that cost money? What kind of funding is going to be available? Fortunately, those projections were worse than the actual reality when it came to the state budget. And so that $3 billion in cuts has been restored. And there's also been a lot of funding for new programs. We were able to get bills passed and funded. And we also had access to a lot of funding from the federal government because of the pandemic, some of which we were able to use to support programs that survivors of domestic violence. So we'll get into that in more detail as well. So just getting into the primary bills we worked on, the first one I want to touch on is House Bill 1255, which is our bill related to firearms and protection orders. This was one, as I mentioned, that that did not make it through in 2020 because of COVID. So we brought it back this year, and we're able to get it through and also make some exciting additional changes and build on the version from last year. So the background on this bill, and the reason we saw this as a necessity is in 2013, Colorado passed a bill that reflected language that's in federal law, and basically said that if someone has been convicted of a misdemeanor crime of domestic violence, or if they are subject to a mandatory protection order or a permanent civil protection order, and the case involved an act or threat of physical violence, that person is prohibited from purchasing or possessing firearms. So that piece was already the law, both in Colorado and on the federal level. The issue we were seeing is that it really wasn't being implemented evenly across the state and being enforced. And there were a lot of survivors who were reporting that their partners or their ex-partners still had access to firearms when they shouldn't, that they weren't relinquishing them, and that wasn't being followed up on by law enforcement or the court. We know that this has still been an issue in Colorado. The Colorado Fatality Review Board in their 2019 report reported that 63% of domestic violence fatalities were firearm related in that year. And also we have nationwide research that says that states that require that someone who's using abusive behaviors provide proof that they have actually relinquished their firearms, that's linked to a 16% reduction in intimate partner gun homicides. So we know that passing laws that ensure that this is actually happening help save lives. That research, if anyone is interested, is from a researcher named April Zioli. Feel free to reach out if you want to actually read that report or see more of that information. So the goal with House Bill 1255 was just, it's an enforcement bill essentially, to make some changes to make sure that firearms, when there were requirements for relinquishment, that they were actually being relinquished. So you'll see that the process starts the same, but then there are some additional pieces that help ensure that enforcement, and I'm going to let Jen touch on some of the differences that we're seeing in the new process with civil protection orders.
Thanks, Amelia. And I think when Brandy sends out the slides, you'll also get a handout that I created that really walks you through all the different steps that are added to this process. So it all starts out the same as Amelia said, with filing for a temporary protection order and then setting a permanent protection order hearing in 14 days. But at the time of that permanent protection order hearing, the respondent is going to be advised that they have to relinquish firearms or ammunition that they have access to or in their possession within 48 hours, 24 or 48 hours. It really is depends on the type of protection order, but in civil protection orders, it is 24 hours. The court can give more time if the person asks for it, another 24 hours. But also at the permanent protection order hearing, the court is going to set a compliance hearing. And that's really the new thing. This idea that relinquishment needs to happen has been part of our law since 2013, but we didn't really have a system in place to make sure that that happened. Some courts were using an affidavit and requiring respondents to fill that out and return it to the court. Others weren't, but we had no follow-up process to ensure that if someone said, yes, I have them, that they actually relinquished them. So for a civil protection order, and it is different for each process that the bill applies to, and I'm really just going to focus on the civil protection orders today, but for civil protection orders, a hearing will be set in 8 to 12 days after the permanent protection order hearing. That then actually gives the respondent 7 days to fill out the affidavit and return it to the court, as well as relinquishing any firearms or ammunition that they have access to. The state court administrator's office was really on top of things, and they've already created all the forms that are necessary for this process. So there's a link in the handout that I created to take you to the state court's page, specifically where all these forms exist. There is an affidavit for the civil protection order, there's one for mandatory protection orders, and there is one for domestic violence criminal sentencing. There's also a receipt form. When the respondent relinquishes, they have to get a receipt, and that includes if they relinquish to a private person. A private person still has to provide a receipt. So the fact that there is a form that the State Court Administrator's Office created makes that easier as well. We're not asking private people to come up with some receipt. They can just fill out this form. So if the respondent returns the form, has relinquished if they do indicate that they had firearms or ammunition, and submits the receipt and takes all of those steps in the 7 days that they're required to do that, then that hearing that's set, that compliance hearing, will be vacated and there won't be another hearing. If they don't, then that is another hearing that the survivor, the petitioner in this case, is going to need to be prepared to attend. So we need to be letting survivors know, first of all, what this new process looks like, of course, and also that this hearing is going to be something they want to attend if they are concerned about firearms. Because what can happen at that hearing if the respondent either doesn't appear or appears and says, I don't have any, and our petitioner says, yes, you do, I know you do, then the court actually has the ability to issue a search warrant. And a search warrant can be requested by the petitioner or by law enforcement, and the judge just has to find probable cause to issue that. So that is another step that doesn't currently exist, that allows for a survivor who says, I got a protection order, but he's still got guns and I'm really concerned, and he's saying he doesn't, or he doesn't show up for this hearing, he doesn't relinquish, he doesn't comply with all of these steps that are now required, the court can take further steps and issue a search warrant, and also issue a warrant for the person's arrest, and make it a violation of the protection order. So there's lots of consequences that can come into play that didn't exist before. So we can add another crime, we can have the person arrested, we can get a search warrant to go to wherever the petitioner indicates the guns are and have law enforcement look for them. The other thing that I think is going to be really important for advocates to know is to really talk to clients about the guns themselves. What are they? How many are they? I know we do some of this already. It's going to be even more important if our client is going to go to court and try to argue for a search warrant, that the client is really able to detail for the court all of the information they have. If they have pictures, if they have any other documentation that they can provide to the court to show that they are, that the guns are there, and request that search warrant. If all of this happens and the protection order is at some point lifted, and the respondent is now able to have guns again, any person that the guns were transferred to, even a private person, is required to conduct a background check before returning the guns. So that puts another burden on a private party, certainly easier for law enforcement or for a gun storage facility, a gun dealer, someone like that, to do that. I will be curious to see if this discourages some of the transfers to private parties. The law does also specifically say that the private party cannot live with the respondent. And I believe that is also new and really important. As we know, the idea of transferring to a roommate or a family member has been something we've really run up against that has been difficult. So the firearm prohibition is going to stay in place for the duration of the protection order. And as you know, a permanent protection order in Colorado is permanent. So unless it is dismissed by either of the parties, this is going to be a lifelong prohibition, and all of those pieces about not being able to buy a gun, not being able to have the guns that you own transferred back to you, are going to apply permanently. And I did see that there was a question in the chat. Courts are required, the court is actually instructed to draft a search warrant. So it is going to be issued by the civil court. That is a new part of this process. how successful we're going to be at getting judicial officers who are issuing civil protection orders at this, I think is going to be up to our advocacy efforts. And that's why I really encourage everyone to work with your advocates to then work with our clients on making sure that they're really prepared. If law enforcement is involved, if it's possible to bring in a police officer who can testify to the existence of these guns and request that search warrant, certainly I think that's going to be helpful. And at Project Safeguard, where we have attorneys working on these cases, that is certainly something we will try to do whenever that is possible. Other questions or comments about the new steps in this process? I'm happy to answer them now before we go to the next slide. Okay.
Okay. All right. So moving on to
Amelia, I'm going to interrupt you right there. Sorry. I just saw that we have a participant that raised their hand, I believe. So apologies. Looks like Erin Shannon has their hand raised. So I'm going to allow Erin for you to be able to talk and if you have a question to ask.
Hi, thanks. Jen, I did have a quick question about whether the petitioner can say, yes, this person has guns, I'm aware of the guns. Like, how much proof or evidence is going to be required in order to, result in the warrant? And maybe that's what you're saying. It kind of remains to be seen.
Well, yeah, the legal standard is probable cause, and that's not a civil court standard. That's a search warrant standard. So it's going to really be enough to convince a judge to issue one. I think in our civil courts, that is going to be something that remains to be seen. I think it's a lot clearer for criminal judges than it is in civil court.
Got it, thanks.
Erin, I'm not sure if you meant to mute yourself, so I'm going to unmute you in case you have some more comments.
No, that was it. Thank you.
Okay, thanks so much.
Okay. Feel free to continue asking questions as they come up. I'm going to move on to the process for mandatory protection orders, which a lot of it is similar, but there are a few key differences. So this, of course, would be in a situation in which a defendant has been arrested because of domestic violence and it's a qualifying domestic violence relationship. Same as with the permanent civil protection orders, their options for relinquishment are to a federally licensed firearms dealer, a law enforcement agency, or a private party who's completed a background check and, as Jen said, does not live in the same household. They complete an affidavit in this process as well. That affidavit includes information on the number of firearms, the make and model, any reason they're still in immediate possession, and also the location of each firearm. But one unique piece on this in the criminal process is that the defendant receives immunity for that compelled statement. So one of the concerns that was raised in conversations about this bill was Fifth Amendment protections. So we have included language essentially saying that when the defendant provides that information on the affidavit, that they receive immunity, that cannot be used against them in any other criminal case, with the exception, of course, of perjury. If they lie on the affidavit, they can still be charged with perjury, but they do receive, other than that, immunity for that compelled statement. And so similar timeline for part of this, they're required to file that affidavit and the proof of the transfer with the court within 7 days. The compliance hearing, however, is not on the same between 8 and 12 days timeline. It can be part of other proceedings that are happening, another hearing that's happening with the case. And just like with the compliance hearings on the civil side, that can be vacated if it's determined that they have fulfilled all of the requirements already. And then if there's no conviction, that prohibition is lifted, but if there is a conviction, the defendant is permanently prohibited from possessing firearms under both federal and state law. And as Jen was saying, same in this process, that if there was not a conviction, in order to get those firearms returned, there would have to be a background check on the defendant.
I just want to add a couple of things, Amelia.
Yeah.
One, I completely forgot to mention the most exciting thing about this bill, which is that this bill eliminates the boyfriend loophole, which, yes,
Yep.
is on the next slide.
Yep.
So it now we've moved beyond the federal definition of intimate partners, and now any intimate relationship, which includes dating relationship, is included in our firearms prohibitions in Colorado, which is a huge deal. And on the criminal protection order, the mandatory protection order piece of this, just like the criminal protection order itself, these prohibitions are going to be lifted anytime the criminal protection order goes away. So, you know, as you know, if you work in this field, those go into place usually when a case is filed or upon arrest, and if the charges are dropped or reduced or anything like that, that can go away, and those firearm prohibitions can go away very quickly. So, you know, the same advice we give about getting a civil protection order in order to have ongoing protection if the criminal protection order might go away, I think is going to be true in considering the firearms prohibitions as well.
Thank you for that, Jen. So some additional advocacy opportunities and tips on this bill. It is now in effect. The governor signed this bill on June 22nd, and it took effect when he signed it. So as Jen said, those forms have already been created and can be used. I'm actually going to show you where they are, and there also will be a link to these in the materials you receive. But on the Colorado Judicial Branch page, self-help forms and protection orders, you'll find a variety of different forms relevant to this bill. We have the proper way to relinquish a firearm, which is just an informational form. And then if we go a little further down, the affidavits are also available on this website, just both for civil and for criminal, as well as the declarations that are proof of relinquishment. So those are all already available, which is great. Let me back over here. As Jen said, it closes the boyfriend loophole. Previously, it was only applied if someone had been married or they shared a child or they had lived together, and we're using Colorado's definition of intimate partner now, which expands the number of relationships that this will apply to. Jen already spoke to the possibility that in the civil process, survivors may need to attend a third hearing. And a couple of other things I just wanted to mention, that granting of immunity and compelling of defendants to make compelled statements, that's something that people have had concerns about, but it has been well litigated. And this is also an opportunity for all of you to reach out to your DAs to help build relationships and have conversations with them about this and remind them that it is now in effect. If you need support with that or you're running into pushback, feel free to reach out to Violence Free Colorado. And also there are several DAs who were involved in the development of this bill and are happy to offer resources and support and answer questions as well, specifically in Denver, Adams, and Boulder counties. And we're happy to make those connections too. So if there's anything that we can do to support in having those conversations in your judicial districts, please just let us know. And I'm going to pause real quick to see if there are any other questions on this bill right now. And if not, that's okay. Okay. So the next bill that we worked on is House Bill 1165. And this one is around providing some financial assistance for survivors who have experienced strangulation. So the background here is, of course, we all know the severity of injuries that can occur when someone has experienced strangulation and the urgent need for medical attention as soon as possible. We also know that sometimes that doesn't happen, and one of the barriers can be financial. We know that sometimes survivors report knowing that they should have sought medical care, or they knew that they needed to, or they wanted to, but they lacked the financial means to do so. We know that survivors of sexual assault in Colorado have access to some funding through the SAVE program, but nothing comparable has existed for survivors of strangulation. And we really just wanted to take a step to eliminate some financial and logistical barriers for those survivors. So what this bill does is clarifies that if a survivor has undergone a forensic medical examination after experiencing strangulation, that that qualifies to be covered by crime victim compensation. And it is not just the forensic exam itself, it is the entire ER visit, all of those expenses. Now, of course, crime victim compensation is a payer of last resort, so insurance would be billed first and things like that, but this is an opportunity to help cover co-pays and deductibles and things like that, and also support survivors who are uninsured to get those costs covered. And the other major piece of this is that it clarifies that I'm sure you're all familiar with the fact that one of the requirements for crime victim compensation generally is cooperation with law enforcement, and that can be a challenge for survivors as well, especially if someone has just experienced a very serious assault like strangulation. Talking to the police might not be easy in that immediate aftermath, or later on as well. And so what this bill does is clarifies that if a survivor receives that medical forensic exam, that fulfills the law enforcement cooperation requirement. So they do not have to also report to the police and cooperate with an investigation or prosecution. Just receiving the exam fulfills that requirement. So the hope here is really just in these really severe cases when we know it's so important for people to get really immediate medical attention because of the risk of things like traumatic brain injuries and strokes down the line, that we want to remove as many barriers as possible. This law is also now in effect. This one was signed back in May, I believe, and is an opportunity for connecting with local crime victim compensation boards and emergency rooms. We are working on creating a TA document around this bill that is a tool that you can use in that outreach that covers the key parts of the bill. The two primary things I think it's most important to remember are that it covers all expenses associated with the ER visit, and that it does not matter if someone reports to law enforcement or not. They still can access crime victim compensation. One other piece that I wanted to mention on this one is the Avoca Fix Act of 2021. This is a federal bill that is currently making its way through Congress, and it's looking to fix some VOCA funding and better secure that pot of money for the future. But one of the pieces that it does is that it allows flexibility for state compensation programs to waive that law enforcement cooperation requirement in more cases. The language that it includes is that requirement can be waived if cooperation may be impacted due to a victim's age, physical condition, psychological state, cultural or linguistic barriers, or any other health or safety concern that jeopardizes the victim's well-being. That bill has passed the House. It has not passed the Senate at this point. We have national partners like NNEDV that are really working on bringing that to the Senate floor and hopefully getting it through. And that's just one piece that we were really excited to see to remove some barriers. Of course, we know that for a lot of survivors of domestic violence, particularly more marginalized survivors of domestic violence, cooperating with law enforcement can present some real challenges. And a lot of survivors, for a variety of reasons, may not be interested in doing that and then not have access to victim compensation. So this, if it passes, which fingers crossed, will provide some more flexibility there for Colorado's state compensation programs. Any questions about this bill? Okay, if they come up, let me know. Next, we have House Bill 1228. So this one came up because some survivors approached a representative, Rec Froelich, because of negative experiences that they had had in some custody cases, and several who had had custody awarded to their abusive ex-partner. And so they wanted to address that issue in some way, and this bill tries to make some steps towards improving that situation by implementing some training requirements. So I would imagine you are familiar with CFIs and PREs, but just in case anyone isn't, these are professionals who make parental responsibilities recommendations to the court. And we know that those recommendations that they make do carry a lot of weight. In Colorado specifically, judges and magistrates will just directly adopt those recommendations about 85% of the time. And these professionals are before this bill passed, until very recently, they were not required to receive any kind of training on domestic violence or child abuse or child sexual abuse. And of course, are working with cases in which those things are happening very frequently. So this bill requires both CFIs and PREs to receive 12 hours of initial training on domestic violence and child abuse. So that's 6 hours on each topic. And then 4 subsequent hours of training every 2 years. So continuing to get training on an ongoing basis. The goal and the hope here is that it will help protect children and help survivors have better outcomes in court. The other piece that it does is placing oversight of the court-related responsibilities of PREs under the State Court Administrator's Office. So this was already the case with CFIs, but if a parent had a concern with the PRE, there wasn't really a mechanism in the court system for them to file a complaint or address that. And so this puts oversight of PREs in the State Court Administrator's Office just for their court-related responsibilities. This bill is also now in effect. It was also signed on June 22nd. The training requirements, obviously, it will take a little bit of time for CFIs and PREs to get that training, but those requirements go into effect in January of 2022. The bill itself does not list, it has some language about the training and it needing to include information on things like coercive control. It does not list specific organizations to provide the training, but Violence Free Colorado has provided information to the State Court Administrator's Office with recommendations of organizations that can provide that training, including, Violence Free Colorado itself, our online learning center. If you are talking with PREs or CFIs who are looking for good options for that training, feel free to reach out and connect with us. I know there are also some local programs in Colorado who are willing to provide training and things like that. So if there are questions coming up in your conversations with court professionals and they're looking for training, feel free to connect with us and we'll help get them connected with some good domestic violence training. And was there another question in the chat? I just saw a little notification and I wasn't sure.
No, we don't have any of your questions right now.
Okay, cool. All right, so lastly, this Senate Bill 292 is around federal COVID funding for programs that work with survivors of domestic violence and sexual assaults and other crimes as well. This was one that came about really just right at the end of session and was a unique opportunity that presented itself to leverage some funding from the American Rescue Plan Act of 2021 to help support survivors. So this bill includes $15 million. I've included just some examples of where some of that money is going, some of the highlights. $3 million is going to forensic nurse examiner telehealth programming across Colorado to help improve access to forensic nurse examiners, because we know not every community has them directly in the community. $1.5 million is going to victim compensation, and then $5 million to DVP. specifically for programming around things like rapid rehousing and flexible spending. So those of you that work for programs that are DVP funded will likely be having some conversations and seeing some of that money. And then $500,000 to the address confidentiality program as well. This is really the first time we've had an opportunity to do something like this. It is one-time funding, but we are hopeful and planning for additional funding opportunities. So there were a few bills that allocated American Rescue Plan Act funding at the end of 2021, but the legislature has a few years to spend all of it. So there's still more money that has not been spent yet. We are planning for and hoping for another bill in 2022 that will direct more of this money to programs for survivors of domestic violence, as well as sexual assault, child abuse, etc. And we will likely be reaching out to all of you and needing ideas and support around this. We're going to be doing some outreach to have conversations around like what the funding priorities should be, what the biggest needs are right now in your communities, the biggest funding needs for survivors. And then when we get into the 2022 session, if we are able to make this bill happen, which I expect we will be, we'll probably be reaching out asking for, advocates and programs to reach out to your senators, to your representatives, let them know what this funding would mean for your programs and what it would help with and the need that you're seeing in your communities. Also, opportunities to testify as well on the bill. So keep an eye out on that. It's a unique and exciting opportunity to really leverage a large amount of funding for survivors of domestic violence. And so we hope to see it happen, and we'll very much appreciate support and ideas from all of you as well. Any questions on that? Okay. So those were the 4 primary bills. We will have some additional, as I mentioned, a TA document on the bill related to victim compensation and strangulation, as well as the firearms bill. And you will receive some information that Jen has already put together on that bill with the follow-up email. When we have our TA docs ready to go, that will be on our website. And we're also creating an end of session report that has some more details on all of those bills and all of the additional bills that Violence Free Colorado weighed in on, but that we didn't go over today because we weren't as involved. I wanted to share just a couple of resources. If you are interested in learning more about any of these bills or any others, the legislature's website is a great resource. If you wanted, for example, to look in detail at the firearms bill, you can just search for the bill number and see the full summary of the bill, the sponsors, the votes and everything, if you're curious how any specific legislator, maybe how your legislators voted on it, and the full text itself, if there's anything you need to look up. Also, pro tip, sometimes bill summaries can be confusing. And if you're looking for a summary just in more simple language, the fiscal note can be very helpful for that. Just summarizes what the bill does in a way that's sometimes easier to understand. You can also learn more about these at our website, Violence Free Colorado's public policy page. This is where we will have the 2021 session report once that's ready to go. I'm hoping to have that up this week or next, as well as those TA documents I mentioned. You can also on this page sign up to receive action alerts from us. So if you are interested, this is more common during the first part of the year when we're in session, but we will send out action alerts with information about a bill we're working on, and we need people to reach out to their legislators and ask them to support it, or we need people to reach out to a certain committee and ask them to vote yes on this bill that we're working on, and hear from advocates, from survivors, why this bill is important. So this is the email list we have where we'll send out those requests, and if you're interested in getting involved in that, you can sign up on our website. You can also sign up for our monthly e-newsletter if you would like to. Another opportunity to get involved is with our Public Policy Committee. This is our committee that meets the second Wednesday of every month. We meet from 12 to 1:30. We meet on Zoom, so if you are in another part of the state, you can still participate. At this point, we are, with session ending, we're in the part of the year where we're starting to move into discussing ideas for next year and what our priorities will be, and what we want to focus on in 2022. You do not need to have any kind of previous policy experience. If you're interested in this and you want to join, feel free to reach out and let me know. I joined when I was working as an advocate and didn't have previous public policy experience, and it's a bit of a learning curve, but a good opportunity to get involved and see what's going on at the state level. So if you have any interest in that, please feel free to reach out. As I said, you can join our action alerts list to get information about when we need people to reach out on bills. We'll also occasionally send out action alerts for things at the federal level as well, things that our national partners are working on. And then lastly, I also just want to put in a plug for training. My position here at Violence Free Colorado, the public policy specialist position, is new, and one of the things that I really want to work on with survivors and with advocates and programs across the state is just education around the policy process and how you can get involved and what it looks like, how the legislature works, what you as a nonprofit are allowed and not allowed to do when it comes to things like lobbying. And I will say you are allowed to do more than you probably think that you are. So if you have a group, if your program, your team is interested in scheduling a training to just kind of do like a policy 101 and learn more about how it works and how you can get involved, please feel free to reach out to me and I would be happy to schedule something with your team. And that is all I have got today, except a thank you and a little bit of extra time if we have additional questions from anybody on any of those bills or anything else policy related you're wondering about.
Amelia, we don't have any questions currently. We do have a thank you that it was very informative and much appreciated.
And Jen, I don't know if you wanted to add anything else on any of those other bills or additional pieces.
No.
Okay.
Thank you both so much for being here and presenting all this amazing information. It's a lot, and hopefully everyone in the audience, if you think of questions as time passes or you're ruminating on all of this amazing information, feel free to connect. And here's Amelia's information. We will, again, send out the PowerPoint, the handouts, and the webinar recording link that will go out later this week. Thank you all for being here.
And actually, another thing I wanted to mention, those documents I mentioned that we're developing, the end of session report and the TA documents, I'll also plan on, when we've got those finished, if you are signed up for our monthly newsletter, on including links in there so you'll know when they come out and be able to access them there too.
That's great. So lots of thank yous. You guys are both awesome. So thank you for being here, and thank you all for being in the audience, and have a wonderful rest of your day.
Thanks for being here, everybody.
Thanks for